في فقرة الأسئلة والتعليقات يمكنكم طرح أسئلتكم وتعليقاتكم باللغة العربية، وسوف يقوم المترجمون بترجمتها عبر يوتيوب. سوف تستمعون للندوة فقط بالإنجليزية. سوف يتوفر تسجيل للندوة مع الترجمة الفورية باللغة العربية على موقع منظمة القانون من أجل فلسطين مع نهاية الأسبوع. شكرا. Back to you, Hannah.
Thank you, Duran. So today's event is organized in collaboration with our partners, the International Center for Justice for Palestinians, the ICJP, the ESCR-NET, Al-Mezan Center for Human Rights, and the ETO Consortium. And we're deeply grateful for our partners and this partnership to make this discussion possible. An essential question that's guiding our discussion today is what's the role of us, activists, lawyers, and civil society to seek justice and accountability for the ongoing atrocities in occupied Palestinian territory. And we must confront an uncomfortable reality. Over 7 decades of apartheid, disregard of international law, and continuing violence against Palestinians persist, as Special Rapporteur Francisca Albanese stated, because the ongoing genocide is lucrative for many, both financially and politically. This harsh truth is evident in the recent international response around the EU-Israel trade agreement. Just last week, when EU Foreign Affairs ministers came together to discuss whether they could potentially suspend the agreement, there was a meeting, and at this meeting, the EU Foreign Affairs chief, Kaja Kallas, emphasized the need of sanctions against Russia to force their hand, while she simultaneously advocated for a wait-and-see approach to Israel, because they're waiting for the extra trucks of aid that could potentially enter Gaza. And this is just to demonstrate how the EU and its member states and other states around the world remain extremely reluctant to even discuss the potential suspending EU's privileged trade position, despite the overwhelming evidence that has been presented by many, particularly Palestinian human rights organizations. And even the bare minimum of sanctioning against, for example, violent settlers, they're unable to do. And also by narrowly focusing the discussion on humanitarian aid and, for example, the counting of trucks entering Gaza, the broader context of systematic injustice and ongoing genocide is deliberately ignored. Weapons trade, corporate profits from land grabbing, illegal settlement expansion, and the destruction of Palestinian property, all of these underscore the urgent need for accountability. Civil society and independent lawyers play a critical role in invoking international law at domestic levels, ensuring states and corporations fulfill their obligations. Because such legal acts truly move the needle, putting significant pressure on states and corporations to subject their actions, or more, their inaction, to scrutiny and meaningful legal challenge. Last Saturday marked 1 year since the landmark advisory opinion by the ICJ, and it clearly states that third states have a duty, not just to refrain from recognizing the illegal occupation, but actually actively bring an end to it. But we've seen states fail. However, we're entering this crucial new phase where the governments are failing, civil society is stepping up and using legal pathways to demand accountability. And I just want to mention some of the promising breakthroughs at the national level that have been happening this week. Just last week, a court ordered the Flemish government to immediately halt all military transport to Israel, citing the Genocide Convention. And for the first time, Belgian authorities must block these shipments going through. And if they don't do it, they actually get fined. And this victory comes thanks to the determination and the effort of also Palestinian and Belgian civil society like Intel, Vredesactie 1111, and the Flemish League for Human Rights. And additionally, the Belgian Federal Police recently arrested 2 Israelis at the Tomorrowland Festival, responding to the legal complaint by the Hind Rajab Foundation and GLAN. This signals Belgium's readiness to exercise universal jurisdiction when credible evidence is presented. And we also see positive developments from states at the Global South. At the Hague Group Emergency Conference on Palestine in Colombia, several states reaffirmed their commitment using universal jurisdiction as a tool for justice and deterrence. These states want to lead in holding individuals criminally accountable for breaches of international law, rather than simply expressing their concern in the sidelines like many other states have done. So we see here, when our states fail us, we have a role to bring about justice. And today we would want to dive deeper into these compelling strategies as presented by our speakers and exploring concrete examples on how we can leverage international law and also national law to demand accountability and justice for Palestine. So with this, I would like to introduce our first speaker, Isam Munis, director of the Al-Mezan Center for Human Rights. And Issam will start off an overview of the role of Palestinian society within litigation and accountability. And he will speak about the pressing legal and humanitarian challenges facing Palestinians today. Thank you, Issam, and please take the floor.
Thank you, Hannah. I'm really grateful for Palestine and partners for organizing such an important and timely event. And thanks for inviting me to join this live stream event. Well, I don't know from where to start actually. Before I decided or to appear, I changed my mind many times what to begin, what to focus on, especially following the news in Gaza. I'm a Gazan, as you know, and my family are there, me and brothers, sisters there. But me and my closer family are in Cairo at the moment. We evacuated Gaza during the war. I'm a cancer survivor, so I need special treatment. That's why this is one of the reasons that I'm away. But my colleagues are there, and I'm in touch with them on daily basis. Look, since we started our meetings 10 minutes, I think by when we finish 8:30, some maybe 7 people were supposed to be killed in Gaza, and some 15 also will be injured. I don't know how many homes or civilian entities to be destroyed. Well, it's the only crime that's being live streamed in the aftermath of the Second World War. I'm not going to talk much because I prepared something that I will read regarding our role as civil society in this field, strategic litigation. But I think it's important to say some or a couple of words here. The Gaza war or the Gaza genocide is not initiating; it's uncovering the real problem of the international order. We naively believe that the order that was set out in the aftermath of the Second World War, aftermath of the atrocities, genocide, Holocaust, destruction, occupation, that the victorious when they met in San Francisco, 1945, and drafted and adopted the Charter of the United Nations. And by the way, half of them were occupying half of the globe, or all of them were occupying half of the globe. But they were, focusing the need to maintain and promote international peace and security, human rights, justice. And this, I mean, Gaza war, the genocide over Gaza has proven to be a complete failure. This system, which now we celebrated recently, 80th, the 80th anniversary of the United Nations, it could not stop the war over, Algeria, Vietnam, genocide in the Balkan, in Rwanda, and also in Palestine. This is quite significant and important, and I think it's time to change this. It's not naive. It's not utopian. I think there is a need to change. But this is another story that we have to consider. There should be priorities. Gaza reveals a lot of things. However, this war is being, as I said, live stream. However, 21 months, and it has not stopped. Half an hour ago, some 25 countries, including UK, France, issued a statement, and they are inviting to end the war. This is really a manifestation of what I said. the crisis, the deeper crisis. This war should be ended. Time is being counted differently, counted by the bill of a medicine, a loaf of bread, a glass of water, a cup of chai. It's being tolerated, and I could easily go for that very racist way. Why is this happening? You know, since the war started, since the 7th of October until now, 400 babies were born and killed during the war. How come this is being tolerated? This is the question. This is the question. This is the question of it's a moment of truth. And I believe there is, you know, this feeling that's clear that there's this, you know, superior culture and the inferior culture. The inferior culture is a surplus on humanity. Uh, Killing of children, babies, it would not make that difference. Otherwise, how can they tolerate the killing of civilians when homes are being destroyed on top of those who are living there, infrastructures were destroyed, hospitals, churches, mosques, and the region of cities, towns, and now Gazans are being pushed uh, 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 in only 12% of the land. So uh, 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 88% of the Gaza land is being under the direct control of the Israeli army, while the people were forced to leave and being displaced tens or 15s times. So it's a moment of truth where things should be clear. The key word we were saying in the past that the worst is yet to come as long as international community is engaging the way that they are engaged with Gaza. The key word was and continue to be accountability. No one is willing to take it seriously. So this is the moment where accountability should be dealt with very seriously. And I think Europe with its role in the war, the genocide, the occupation in Gaza, I think Europe should be ashamed of itself. Europe could not seize or freeze the association agreement. And just to end with the fact that we have been engaging with Europe capitals or Brussels for decades. And when we are in Brussels, people used to tell us, no, the problem is not here. The problem is in the capitals. And when we are in the capitals, say, no, you know how decision making of the EU, so it's the problem is in Brussels. By default, Europe is part of the problem because in times of genocide, neutrality, or put yourself aside is in fact, being explicit in genocide. So it's either or. You cannot claim that you're neutral trying to do some business here and there. We as civil society has deeply engaged with the national and international courts, and Palestinian civil society has a long and committed history of using global strategic litigation to fight for justice and human rights and to break Israel's long-standing impunity. Human rights organizations have played a central role in documenting violations, supporting victims, and bringing legal cases before both domestic and international courts. For years, the Mezan Center for Human Rights actively engaged with the Israeli legal system, submitting hundreds of legal complaints, many involving grave breaches of international law that amount to war crimes and crimes against humanity. Some of these cases were litigated all the way up to the Israeli Supreme Court. Yet, despite the scale and seriousness of the violations, not a single case has resulted in a criminal conviction of Israeli soldier or authorities. The extensive experience has led us to a clear conclusion that the Israeli legal system is both unwilling and unable to deliver justice for Palestinian victims. As a result, we have focused increasingly on pursuing accountability through international legal mechanisms. Some important efforts include submitting Article 15 communications to the International Court, ICC, engaging with the United Nations, including the human rights committees and special procedures, filing universal jurisdiction cases in countries around Europe and the world. Unfortunately, these efforts have come to a high price. And this is very important also to highlight here. Many leading organizations have been criminalized and targeted by the Israeli government. This shrinking space for civil society is no accident. It's designated to prevent Palestinians from seeking justice. As you know, this sword on the necks of Palestinian civil society and international civil society as well, that criticizing the occupation is act of anti-Semitism. This should not be accepted. However, a lot of prices have been paid because of our demand for accountability. In the West Bank and East Jerusalem, Israel continuously expand its illegal settlements, demolish Palestinian homes, and forcibly displace Palestinians from their land. These actions are part of a deliberate policy of de facto and de jure annexation in clear violation of international law and are part of a larger system of colonial domination and fragmentation. In recent years, there are also been a sharp rise in settler violence, often carried out with the support or protection of the Israeli military as part of the broader strategy to push Palestinians off their land. At the same time, Palestinians are being imprisoned at unprecedented levels. More than 9,000 Palestinians are being held in Israeli prisons, including hundreds of children, over 3,000 under administrative detention without charges or trials. Mass arrests and systematic abuse in detention are being used as tools of collective punishment and repression. I think I ran out of time, but I'll try to summarize as much as I can. In Gaza, situation meets the legal threshold of genocide. Since October 2023, Israeli military campaign and total siege have led to the killing of at least 60,000 Palestinians, including thousands of children. Homes, hospitals, schools, and entire neighborhoods have been wiped out. Hunger, disease, and trauma are widespread. All of this takes with a broader context of structural impunity, despite clear evidence of great breaches of international law, including war crimes, crimes against humanity, and genocide. There have been no accountability. Israeli officials continue to act without consequences, while many states provide diplomatic cover, arms, and funding. In this context of widespread violations, strategic litigation remains one of the few available tools to challenge Israel's immunity and demand accountability. It's not a quick or complete solution. It cannot replace political action, but it can make a difference. Strategic litigation serves several key purposes. It puts legal pressure on states, companies, and international institutions to fulfill their legal obligations under international law. It also helps build a historical and legal record affirming that Palestinians are not just victims, but rights holders or right holders under international law entitled to protection and justice. We see the approach in action at the International Criminal Court, where Palestinian human rights organizations have submitted evidence of Israeli crimes, Israel's crimes committed in the occupied Palestinian territories for over a decade. We also see at the International Court of Justice, which has also issued two advisory opinions relevant to Israeli occupation of Palestinian territory and is currently hearing the continuous case brought by South Africa under the Genocide Convention, accusing Israel of committing genocide in Gaza. This case represents a major step in holding Israel accountable. But some of the most urgent and promising work today is happening in national courts through universal jurisdiction and third country accountability mechanisms, many of them initiated by Palestinian civil society. Al-Mezan has filed several key cases with partners to challenge both direct violations and third-party complicity. In Germany, legal action to stop arms export to Israel. In France, complaints against the Israeli finance minister, a dual French-Israeli national, for alleged torture in Gaza. Complaint in France against two French-Israeli snipers for summary executions in Gaza. In the Netherlands, a case against the Dutch government for failing to prevent genocide and supporting arms transferred to Israel. To conclude, even with all those challenges, Palestinian civil society remains strong, committed, and focused on justice. Strategic litigation is one tool among many, but it is a powerful one. It shows that international law still matters and that complicity from other states and companies must be released or must be addressed. Thank you.
Thank you, Isam Munis. And thank you for sharing all the efforts by Al-Mezan and how, regardless of the criminalization in the shrinking space, you're still continuing with your work. So thank you for that. The next speaker that I would like to introduce is Haydee Dijksta. She's a bursar at 33 Bedford Road, Chambers, and she's the chief counsel at the ICJP. Haydee will introduce the concept of universal jurisdiction, connecting it to strategic litigation, and she'll share examples of ICJP's work as a case study. And I kindly ask you to speak slowly for the interpretation. Thank you.
Well, thanks very much, Hannah. And let me just start by thanking the organizers for putting together this important discussion. As Hannah had said, I'm instructed as counsel for the International Center of Justice for Palestinians, ICJP. And just to introduce quickly, ICJP is an independent organization of lawyers, politicians, and academics who support the right of Palestinians and aim to protect their rights through the law. So looking at projects and cases under the law for this protection. It's based in London as well. As Hannah said, I'm going to speak about universal jurisdiction and to speak about ICJP's work along with partners in this area and this avenue of seeking accountability and justice. And so what I want to do is highlight one project in particular that ICJP has launched and has been quite active with, which is their Global 195 campaign. So ICJP's Global 195 project is a worldwide legal coalition dedicated to addressing war crimes and crimes against humanity in Gaza by seeking the truth through full and transparent domestic investigations and accountability through potential prosecutions of alleged perpetrators, including Israeli or dual national individuals, where there is sufficient evidence of individual criminal responsibility. ICJP seeks to utilize all tools under international law to seek justice and accountability while closely at the same time monitoring the very real and worrying attacks against international law, the rule of law, and institutions that are central to this, such as the International Criminal Court. Therefore, with the spirit of looking at all avenues and using all potential routes to justice, this project, the Global 195 project, focuses on international law, which has been accepted into domestic law through the principle of universal jurisdiction and how this allows states to examine and potentially prosecute serious international crimes. So let me back up for a moment and just explain a little bit about universal jurisdiction for anyone who isn't familiar with the principle. Universal jurisdiction, or extraterritorial jurisdiction, essentially adopts the theory that some crimes are so serious and so harmful to international justice that they must not go unpunished and must be addressed, no matter where they're committed, no matter by whom or against whom as well. The nationality or the citizenship of the person or the perpetrator or the victim, it does not preclude bringing a case. And with this understanding, states adopt into domestic legislation they adopt laws which enshrine international crimes and allow them to exceptionally exercise their competence over these crimes despite the absence of that territorial or nationality link. So just going back to ICJP's Global 195 project, ICJP seeks to see a global coalition of legal professionals, groups, and organizations with which take steps with the assistance of ICJP's legal, investigative, and advocacy teams to seek legal measures under the principle of universal jurisdiction. So this, depending on the procedures in the domestic jurisdictions, this could be applications for private arrest warrants, the initiation of investigations or legal proceedings where there's evidence and crimes of the crimes that can be brought forward. And then it also seeks to conduct advocacy as well for states' legal agencies to perform their duty as per their national laws as well. ICJP sees this Global 195 project as so important for two reasons. One is the limitation of some of the international legal routes that we often think of, like the International Criminal Court. For example, the International Criminal Court's legal framework itself is limiting of the scope in which it can examine crimes and perpetration, given that the International Criminal Court is meant to prosecute those most responsible. So it means that a number of potential perpetrators do not fall within their mandate. So universal jurisdiction gives the opportunity for proceedings to happen in domestic jurisdictions for international crimes that can cover a much wider scope of perpetration. The other reason that ICJP is looking at universal jurisdiction is particularly given the fact that recently there's been such attacks on places like the International Court and certain legal remedies. So looking to those domestic jurisdictions to fill that gap. And to make sure that not only are there avenues for accountability and for justice, this being the primary purpose of seeking measures in domestic courts under universal jurisdiction, but also for the simultaneous goal of contributing to future deterrence. So making sure that potential perpetrators are aware of these avenues for accountability despite the limitations of other international mechanisms, and that this might remove a culture or a narrative of impunity. Just a bit more about the project, and then I'll just speak about one case. I'm mindful of the time. The Global 195 project, it works with partners around the world to help with drafting and filing cases in various domestic jurisdictions. It works with these partners to prepare the applications, but then also to look at advocacy strategies as well. At the moment, ICJP has worked with partners. It was launched earlier this year, and in the 6 months since it was launched, it's worked with domestic partners to file 7 cases around the world, and has also mapped out more than 80 lawyers and other legal experts in 26 different jurisdictions to work on bringing those cases forward. And those conversations are ongoing. And I know ICJP is always interested in connecting with other partners who might be interested in bringing these types of cases. So with the time I have remaining, I just want to quickly just give an example of one of these cases. And this was a case that was, or a complaint that was brought in Namibia. It was brought with ICJ's assistance and working with their partner, the Center of People's Resistance in Namibia. It was filed in April of this year and came with a request for the opening of a criminal investigation. It was filed before the head of police within Namibia's criminal investigation unit of the police. And it utilized evidence that was collected and analyzed by ICJP and along with their partner as well, and looked at the following crimes which are instilled in Namibia's domestic legislation. It looked at indiscriminate attacks on civilians, indiscriminate attacks on civilian property, looked at attacks on specifically protected property. So what we often think of, either sites that have cultural value or religious value, or our hospitals or places for medical facilities as well. And it also looked at intentionally using starvation as a method of warfare and blocking humanitarian aid. And lastly, willfully causing great suffering and serious injury to body and health. And that was under Namibia's Geneva Conventions Act of 2003. This is the domestic legislation in Namibia, which incorporates provisions of the Geneva Convention and says that any person who's in Namibia or elsewhere and commits, or who is an accessory to the commission of these crimes, can be investigated and potentially prosecuted in Namibia. This, as I said, it was filed in April. So given the amount of evidence that was submitted with this complaint, the update so far is the acknowledgement from the police that they are actively looking at the complaint, and noting that this was the first time that they had received such a complaint, and that they'd be thoroughly examining it. There is no particular timeline to this complaint under their procedure, so it's something that ICJP and their partner are actively following up on. So let me just pause there and happy to take any questions during the Q&A. Thanks.
Thanks so much. And thank you for sharing more on the Global 195 initiative in this case. It's very interesting indeed. Then I would like to move to the next speaker, which is Robert Grabosh, and he's a German lawyer based in Berlin and is advising on business and human rights since 2011. Robert, please take the floor.
Yes, hello everyone, thank you. In my work, I focus on the duties and liability of companies under administrative law and civil law. The United Nations have adopted the United Nations Guiding Principles on Business and Human Rights in 2011. Those guiding principles demand that companies respect human rights in all their global operations, and they require states to ensure that companies actually do so. For instance, national legislators can pass legislation requiring companies to mitigate human rights risks in their own operations and at suppliers. And since the UNGP were adopted by the UN, several countries have indeed passed due diligence legislation for that purpose. In Europe, most notably France, Norway, and Switzerland have passed such legislation, and Germany. The German Supply Chain Due Diligence Act of 2021 might actually well be the most ambitious of such legislation at domestic level. So let me tell you about one case that I worked on as one of over 10 lawyers from Germany, Palestine, and Israel. Not long after 1967, Zionist settlers entered the West Bank and took Palestinian land. And this trend has accelerated several times since then. And right now, the movement has become particularly violent. At the beginning of last year, The Intercept broke the story that a subsidiary of the German media company Axel Springer SE operates an online platform similar to Craigslist, on which settlers find their future homes. Hannah, if you could pull up the advertisement, you will see now an advertisement that has been published by that subsidiary in Israeli print media. And you see here that they are advertising their product by saying, if you translate it to English, Judachdine, that's the name of the platform. Judachdine helps you to look forward, to build a future in your next home in Israel. There is Judachdine, and we have no other land. And you clearly see here that Palestinian territories are omitted. It is all depicted as one land that has basically annexed the West Bank and East Jerusalem, and even Gaza. And thank you, Hannah. So a year ago, after that story broke, I started researching this case together with the Jerusalem Legal Aid and Human Rights Center, JLAC. And we found that the Israeli company is a limited company that is ultimately held 100% by the German head office, Axel Springer SE, headquartered in Berlin. We also found that there was a group-wide compliance management system, that some of the staff working at the parent company also works at intermediary companies. So there were many signs showing us that the German company Axel Springer actually controls this online platform. So we clearly saw a responsibility of the German Axel Springer Group under the German Supply Chain Due Diligence Act. The Supply Chain Due Diligence Act of 2021 in Germany requires all German companies with 1,000 employees or more to identify and mitigate human rights risks at their suppliers, but also, and even more so, in their own business area. The German law identifies 11 human rights risks, and one of them is the illegal taking of land grabbing. So the Springer Group was required to identify this risk, among others, and ensure that its Israeli subsidiary avoids listing the illegal occupied territories. And since it obviously failed to do so, it was on the German supervisory authority, BAFA, to initiate investigations, issue orders to suspend the listings, and even to issue a fine of up to 2% of Springer's global annual turnover against the Springer Group. So therefore, JLAC and us German lawyers prepared a complaint that we handed in November at that supervisory authority, BAFA. It was the villages of Mara, Iskaka, and Taibe. They are just about 12 to 15 kilometers northeast of Ramallah. These 3 villages filed the complaint together with 5 individuals who have lost their land in those villages and are about to lose even more land. Some of them are about to lose even more land. The supervisory authority has rejected the complaint for 2 reasons. One reason was that the 5 individuals asked the authority to not reveal their names to Axel Springer SE because their life is in danger, obviously. The authority did not offer to protect the identity of the complainants and insisted that they tell their names. And since the complainants refused to do so, the authority then rejected the complaint for that reason. And the second reason was that the authority thinks that villages and municipalities cannot be rights holders in case of land grabbing, which we do not agree with, obviously, because the German Supply Chain Act identifies as a risk the illegal taking of land that serves people for their livelihood, for instance, for hunting as a resource for water and for food. So who else would be able to file a complaint in case public land is being taken? So anyways, the authority rejected the complaint, and we filed an objection against the rejection. The objection is now pending for review by the German Federal Ministry. And meanwhile, we learned that the Axel Springer Group has recently finalized a merger and acquisition deal. The listings, the classifieds business of the Springer Group has in April been transferred to an American and a Canadian investor. So now the Axel Springer Group is not responsible for that online platform anymore, accordingly. However, we see in conclusion that there are laws in place already that can be utilized to hold companies accountable if they don't apply what we call due diligence legislation, HRDD, human rights due diligence legislation, to mitigate their contributions to human rights risks. Case in point is this German Supply Chain Due Diligence Act. There are other legal avenues as well to hold companies accountable. For instance, there are import bans in place at the European Union levels. Currently, import bans against products from forced labor, but in theory, it would be possible to extend them also to products from pillaged resources, resources taken from occupied territories. France has a civil liability law, the Loi de Vigilance of 2017, which gives victims the right to hold corporations accountable in court, to sue damages from corporations directly in French courts. So in this case, we failed, but we believe that this is not because of a weakness of the German Supply Chain Act, but because of an unwillingness of the German government. But legislation can be effective at reducing business complicity and human rights violations. So I would end here, and I'm happy to take questions by you.
Thanks so much, Robert. I would like to now move to our final speaker, which is Gary Liston, senior lawyer at Glenn. And Gary will address the corporate complicity of Israeli crimes, focusing on anti-money laundering and the proceeds of crime regime. Gary, please go ahead.
Thanks, Hannah, and thanks everyone. I'm very grateful for the opportunity to be able to join you this evening. And just to briefly say a quick word about GLAN, or the Global Legal Action Network. We pursue innovative legal actions which aim to challenge the involvement of powerful actors in extreme human rights violations and in environmental harm. And our work on direct accountability in relation to Gaza was previously mentioned at the recent arrest of the soldiers in Belgium with the Imre Jab Foundation, and also work on challenging UK arms sales to Israel. But I'm not unfortunately going to be able to focus on that because that's the work of another colleague. So as Hannah mentioned, today I'm going to focus instead on our work in trying to apply the proceeds of crime and anti-money laundering regime to commercial activity that is linked to Israeli crimes. And I'm specifically going to focus on our work in targeting Airbnb and its role in facilitating accommodation in the elite settlements. So first, I think we just help to briefly explain what money laundering is. Essentially, it's the handling of any money or other property that is the proceeds of crime, where the person handling the property knows or suspects that this is the case. And in most European jurisdictions, this can be the proceed of any crime, including a war crime. And it's helpful, I think, to contrast money laundering with accessory liability. With accessory liability, essentially, we're talking about a situation where someone gives some assistance or helps, gives something towards the commission of a crime. Whereas with money laundering, we're talking about what someone receives from the crime. And there's some key distinctions between how the two regimes operate. The remoteness of a person or a company connection to the underlying crime is not really an issue from a money laundering perspective. But in relation to accessory liability, this can be a very real issue. And similarly, while there's a requirement in some jurisdictions, at least, for substantial assistance or for intent to be established in relation to accessory liability, this is not true for money laundering. So just to illustrate these points with an example, imagine a bank is lending money to an Israeli construction company, and that company uses some of that money to build an illegal settlement or to help build an illegal settlement. Certainly under the Irish or the UK regime, which is the area of domestic law that I practice in, it would be extremely difficult to establish that the bank in that situation is liable as an accessory to the war crimes that are linked to the settlement construction. And this is essentially because the activity of the bank, legally speaking, is the connection between that activity and the crime is too remote. And in some jurisdictions, as I said, there would be a need to show that the bank intended to assist the crime, and that can be difficult in a commercial context where banks and other companies are simply just intending to make a profit. But these same obstacles, as I mentioned, they don't arise at least as much in the anti-money laundering regime. So as I mentioned, we sought to test the application of this area of law in both Ireland and in the UK in relation to Airbnb. We've submitted criminal complaints both to the Irish authorities and to the UK authorities against entities of Airbnb in both those jurisdictions, because it is both of those entities which are responsible for enabling accommodation in the illegal settlements. Essentially, if a settler wants to list a property on Airbnb, they contract with the Irish company and then the UK company collects payments on behalf of the Irish company. So in Ireland, we submitted our complaint against the Irish entity back in August 2023. And essentially, there are many different aspects of the complaint, but essentially we said that because the revenue that's generated through the rental of properties is in the settlements is linked to the war crimes that underpin those settlements, that the Irish company is handling the proceeds of those war crimes and is therefore committing a money laundering offence. This is a very similar argument that has been made in the Netherlands by the European Legal Support Center and partners in relation to Booking.com. And as far as I know, both cases are the first ever cases to apply the anti-money laundering regime to commercial activity linked to the illegal settlements. So in Ireland, the Irish police back in November of last year indicated that they were refusing to open an investigation because they said that our complaint, which was I think nearly 40 pages long with thousands of pages in annexed material, they responded with one short paragraph saying that the complaint discloses no offence within the jurisdiction of Ireland. And under Irish law, as in England with the common law system, it is possible to bring judicial review proceedings against any public authority, including the police, where they have made an error of law, or at least where it's arguable that they have made an error of law. And so our co-complainant in this case, an organization called SADACA, the Ireland-Palestine Alliance, and a Palestinian individual whose anonymity is being protected by the court, brought judicial review proceedings a number of months ago, on the 9th of May, in the Irish courts against challenging the decision of the Irish police on the basis that they have made errors of law in reaching their conclusion and deciding not to open an investigation. And this particular case is following a precedent that we were able to set in a very different context in the English courts, where similarly we made a complaint to the National Crime Agency in the UK a number of years ago. This was in relation to goods produced with forced labor in the Xinjiang region in China. And we argued that those goods were criminal property under the UK Proceeds of Crime Act, and that the National Crime Agency should therefore investigate companies that are importing these goods. And again, the National Crime Agency declined to investigate, and this ended up in the Court of Appeal in England last year, and it delivered a ruling which confirmed that goods produced with forced labor are the criminal property and remain criminal property no matter how long the supply chain and how many steps they pass along the supply chain before they arrive in England. So it was a very important case in that it clarified the application of the money laundering and proceeds of crime regime in the UK to an human rights abuse that had never been the subject of a investigation under that particular legal regime. So similarly, in this case against Airbnb, we are hoping that the Irish courts will clarify that they won't make any finding about the liability of Airbnb specifically, because that's something that only a criminal court can do. But what they can do is clarify, and what we hope they will do is clarify that commercial activity in the illegal settlements gives rise to serious risk of liability for a money laundering offence, and then return the matter to the Irish police to take a decision on the correct legal basis. And the consequence of that ruling, I think, would be very significant, well beyond Ireland. Firstly, because the EU the anti-money laundering regime in Europe derives from EU law. So while there is some variation across EU member states, there's a fundamental similarity to the regime. And one aspect of that regime is that it imposes anti-money laundering due diligence obligations on entities such as banks, accountants, and law firms. So this would impose positive obligations on these types of entities to ensure they are not linked to any other business that is engaged in commercial activity in the settlements. And finally, I'll just say that while I focused on on crimes related to the settlements, this principle would not necessarily be limited to activity in the settlements for two reasons. Firstly, because, as we know, the Israeli settlement economy is completely integrated into the wider Israeli economy. So money is passing across the green line in both directions on a daily basis. So any company doing business with an Israeli company is at risk of handling money that is tainted by the crimes underpinning the settlements. And secondly, we are starting with predicate offences such as the transfer of civilian population onto occupied territory and the unlawful appropriation property in occupied territory. But there are other crimes to which this principle and this area of law could be applied, including the crime of apartheid, and that is obviously a crime which is being practiced from the river to the sea. So that's just a very brief whistle-stop tour of this area of work that we're engaged in, and yeah, more than happy to take any questions anyone might have on that. Thanks.
Thank you, Gary, and thank you for also putting it in the larger context and the larger significance for other countries on this important case. I would now like to open the floor for questions from the audience. We've already received quite a few questions in the Q&A chat. Now I'll group them in groups of 3 to different speakers, and then the speakers can answer whatever question they either feel is geared towards them or that they feel relevant to the topic. And then once you've answered, I can go to the next 3 questions that have been raised. So I would like to start, let me see, with a question to Haydee. And that is on if a state claims power beyond its own territory, so the extraterritorial power, isn't this power meaningless unless they can actually enforce it in another place? And the second question is it mandatory, the mandatory service for Israelis, so the fact that they have to go mandatory to the army, a barrier for going after individuals of the IDF, even if there's a strong evidence that they have committed atrocity? And the third question is for Robert. And that's if a member of the public encounters an advertisement that you just showed, what's the best course of action and what would you advise them to do? Haydee, please go ahead.
Well, let me just, first of all, thank you for those questions. Let me just start with the first one on enforcement for universal jurisdiction. That is certainly something that needs to be considered because if a domestic jurisdiction does move forward with investigating evidence of crimes and then moves on to the potential prosecution of an individual, then that is something that absolutely needs to be considered, whether that person might be then in the territory of that country in order for there to be an effective prosecution. One thing that I haven't seen as being available is trials in absentia. So it certainly does mean that that individual would need to be in the territory of the location that's trying to prosecute that person. So part of the analysis in a lot of domestic jurisdictions is what's the likelihood of there being a successful prosecution, with that being one of the considerations. So part of therefore putting together a complaint that is strong enough to convince a domestic jurisdiction or law enforcement agency or prosecutors to move forward is to analyze what's the likelihood that this potential perpetrator, which you have evidence of their responsibility, what's the likelihood that they will be on that territory, traveling there, or what connections do they have to that territory that would mean that they're likely to come. So that's some of the evidence that needs to be collected as well. But it is certainly something that's an important consideration when looking at evidence of perpetration and who to put forward as a potential perpetrator. On the question of mandatory service, I think if I understand it correctly, that's the question is whether that can be used as an effective defense for crimes. Okay. I mean, I think my answer would be that when looking at the responsibility of a perpetrator, it's based on what their actions were. So whether or not they were obliged to become part of the military and to be there, what they're judged on is what actions they carried out. And so one of the things that is often cited in international criminal law and domestic criminal law as well is rejecting unlawful orders of your superiors and not carrying those out. If a soldier believes that the orders that they receive are unlawful, then they do have a duty to not carry out those orders or to resist them. So I think my initial response would be that just the fact of having to serve in the military is not enough to overcome the responsibility that comes with that individual's actions.
Thank you, Haydee. Robert, would you like to answer the third question?
Yeah, sure. Thank you for the question. Well, if you see advertisements similar to the one by Judachdine that I have showed you earlier, then several legal consequences might be possible. It may be a case of criminal liability, because whoever files advertisements like that may be aiding and abetting war crimes such as settlements in occupied territories, or in case of other adverts, it may be pillaging and dealing with property that has been taken from illegal transactions. Or it may be a case of liability under due diligence legislation, such as under the German Supply Chain Due Diligence Act. So one would need to research who is ultimately responsible for these kinds of advertisements. If perhaps a parent company has actual control over whoever filed that advertisement. So there may be officers who have known and decided or omitted to avoid these adverts. And it's quite a bit of legal research to do. And then in that case, you should inform NGOs that have lawyers working for them or that frequently liaise with external lawyers working on cases like that. That would be what I would advise someone to do. Also, if I may add to extraterritorial jurisdiction, the European Union has last year required all EU member states to pass similar legislation to the German Supply Chain Act, which I told you about. It's called the CSDDD, the Sustainability Due Diligence Directive. And this directive, this European legislation, applies also to non-European companies that have 450 million euros turnover in the European Union. So obviously we also, with regard to this responsibility, we ask ourselves, how do we enforce this legislation vis-a-vis companies outside of the European Union? And that directive requires all those non-EU companies to have a representative within the European Union through which European authorities can initiate investigations and issue fines. This issue of extraterritoriality is already a problem that we are aware of, and it's possible to handle it with regard to the due diligence legislation.
Thank you, Robert, and thank you for the interesting addition. Then I would like to move to the second group of questions, and I see there are many more coming in. So the first question is to Gary, and they ask, in the context of money laundering or anti-money laundering, if a bank has been made aware of the illegal activities of their clients and continues to finance them, is it then possible to prosecute them based on the compliance or AML breach? Would it be possible to prosecute commercial companies that are supporting the illegal activities perpetrated in Palestine? My second question is to Issam, and it's how can diaspora-based lawyers, particularly those working with the Palestinian refugees or asylum seekers in the US, better align or work with the priorities of legal organizations on the ground like Al-Mezan? And the third question is to Haydee, and it's that the universal jurisdiction has been used by Palestine several times, including the case of Steve Levin in the UK, Ariel Sharon in Belgium, and Darren Among in the UK, and a case in Spain. And that's because the lack of political will has been blocked from prosecution. And how do you think you will overcome these political limitations? And I would like to ask Issam to take the floor first.
Well, thank you, Hannah. Well, I think always there is a room for cooperation. However, our main work at the moment, as you know, is accountability with the full broader. On the ground, we face very serious difficulties. As you know, our staff has to be displaced. They have been displaced many times, and most of their homes have been destroyed. And our priority, to be honest, for our staff is their safety and the safety of their families. Then comes what? Due to the unprecedented, violations, talking about genocide, I think you need an army of lawyers and workers on the ground to follow up everything, cases, and to document, especially for a human rights organization, because we do not rely on kind of hearsay sort of sources or evidence. We rely on our sources, victims or potential victims, eyewitnesses. So it's very, very professional work. And as you know, credibility in our work is a must, and we're very strict on this. Especially we're under attacks as all the time. So to cope with the violations that are taking place, war crimes and crimes against humanity, genocide, it's to be honest, it's too much. Especially when it comes to the other side of documentation, talking about autopsy reports. As you know, hospitals are not functioning properly. Even doctors, forensic doctors, many either have been maybe killed or detained, and also forensic labs and this stuff is not anymore in Gaza. So and those are kind of compulsory, they're important in our work, in addition to many other sources that are very, very important. So on the ground, we face a lot of challenges, but we still can do our work. Even due to sometimes the collapse of network and communications, how people to communicate, for example, in terms of people disappeared or detained, how to follow their cases. It's not easy job. How to communicate with our staff, especially our staff are moving here and there with their families, and definitely so they don't have addresses, neither the victims nor the human rights workers per se. So they're tense and moving. So it's a real challenge. But when it comes to the other part, I mean, definitely there is a room for cooperation with friends, lawyers in the States, whether refugee lawyers or lawyers work on asylum seeking. Yeah, always there is a room, but I mean, to be honest, we are focusing mainly on issues raised by the colleagues. It's the priority, and our top priority, item one on the agenda, is how to stop the war. To be honest, and again, time is being counted now differently. So that's the priority: how to work together to stop the war, to stop the genocide that's executed over the Jews. Then the list, the shopping list is very full. There are many areas to cooperate with others, and always there's a room, definitely. Yeah.
Thank you, Issam. Gary, would you like to answer the second question?
Sure. So yeah, I think I'll take the question in two parts. Firstly, if a bank were made aware of its connection to Israeli crimes, could it be liable? And the making aware of a bank or any other entity is a critical step in establishing liability for money laundering. And it's actually something we do, not just in the context of Palestine, where we, in the case of Airbnb, wrote to Airbnb entities to ensure they have the requisite knowledge. But we've also done this in other contexts as well in relation to environmental harm. So yeah, the making aware of the target entity is something that can have a significant relevance to liability. And then as to whether they can be prosecuted, in principle, yes. In the UK context, it's possible to bring a private prosecution as a private individual all the way to conviction, although the authorities, the prosecution service, can take over a prosecution. But in order to succeed with a prosecution, either brought by an individual or brought by the authorities, it would be necessary to have evidence, not just of the knowledge, but connecting the revenue from the crime all the way back to the bank. And it sounds easy in some ways, but it can be challenging to get that evidence. Although what we have tried to do in some cases is to say, well, we don't have the investigative powers that the authorities have to access that kind of evidence. So the responsibility is on the authorities to use their powers to obtain that evidence. But yes, in principle, once knowledge is established, a prosecution can be brought for money laundering.
Thank you, Gary. Haydee, would you like to?
Thanks. So I think the question was about the challenges after filing a complaint under universal jurisdiction, particularly with the will of the domestic jurisdiction to take it forward, which is certainly something that we have seen in quite a few universal jurisdiction cases and complaints, even to the extent where there isn't a willingness to even bring it forward for investigations, which can be quite frustrating. I think the way I'd answer this is first of all, it really emphasizes the importance of carefully preparing these complaints and doing it quite intentionally to make sure that the strength of the evidence is really what's leading it. And I think that is coupled with, so making sure that the complaint is strong on the law and is well supported by evidence and carefully crafting that. And coupling it with that public advocacy that goes along with it as well. So to highlight the strength of the evidence that would make it hopefully harder for the domestic jurisdiction to not even take, the preliminary steps of opening an investigation. I think, the fact that the strength of the evidence is so important, it also highlights the importance of these coalitions, like what ICJP is trying to do with this coalition for Global 195, coming together, analyzing evidence, combining evidence together and working collectively in order to make sure that these types of initiatives are as strong as possible. the last thing I wanted to highlight was the fact that some of the submissions that need to be considered in these complaints that go along with part of the arguments that need to be made speak directly to that as well. Oftentimes, depending on the domestic jurisdiction where it's being filed, you do need to look at public interest of the domestic jurisdiction taking these forward, and potentially even what connections to that jurisdiction might help to move that forward. It might not necessarily be a requirement because, of course, this is universal, as I reviewed before, but highlighting things like any victims that are connected to that territory that might be residents or citizens that provide evidence that can be compelling for the domestic authorities to feel that pressure in order to move things forward because it does have that connection. And sorry, one last thing to consider is the possibility, depending on the jurisdiction and what is available, if there is a procedure for judicial review that could be explored as well, depending on what exactly the decision was not to move forward with an investigation or a prosecution, seeing if that's a possibility in the domestic jurisdiction as well.
Thank you very much. Then I have the following 3 questions. The first one for Gary, because I know you have to leave us soon. And it's whether you personally or GLAN as an organization has also faced threats, harassment, or professional retaliation for your work. For example, here they ask about the revocation of your license and how do you navigate these challenges? And the following question that would also be like to be asked is on the infamous statements on the concentration camp or deportation of Palestinians, and this one's for you, Issam. How has it been dealt with? Has it been reported to international mechanisms? And what kind of process could follow these kind of statements? And then there's another one for Haydee regarding someone who says, I'm a US-based immigration attorney working on asylum and human rights cases for including Palestinian clients. And they're asking for legal professionals like them, who primarily operate in the domestic US system, what are the most meaningful ways to contribute to universal jurisdiction efforts, strategic litigation, or corporate accountability campaigns? So Gary, first you, and then Issam, and then Haydee.
For the question, the short answer is no, we haven't faced any targeting of any kind so far, and I'm always conscious of the comfort and relative luxury from which we can do our work in GLAN compared to what so many Palestinians, the threats that they face hourly in all sorts of contexts, including in working for civil society organizations. So yeah, I guess that's a short answer.
Thank you. Issam, I would like to give the floor to you next.
And I did not get the question, to be honest. Sorry for that.
No problem. The question was regarding the recent statements on the potential concentration camp or the humanitarian center in Gaza, and what kind of actions are taken at the international court level, at the ICC or ICJ, regarding these statements. If any action is possible, is one of the questions that was asked.
Yeah, as you know, this plan, the constitutional plan, which has been condemned by almost all actors, Europeans, and even the Israelis, many of them were against. But it's very, very racist. And finally, it's a constitutional camp. It's prerequisite for the expulsion and ethnically cleansing Palestinians. Definitely, we expect the ICC, the ICJ to consider this, but we did not hear that it's being under the process at the moment. We're not sure if it will take place. Still, there are talks between the different parties. We heard that in principle, the Mirage corridor which the Israel insisted to keep it as, again, prerequisite for the establishment of this the concentration camp, the what they call humanitarian camp in Rafah. If it's being agreed that it will not be under the Israeli control, then I don't think there is a chance for as they plan for it, that city, that concentration camp. But on the other hand, I think uh, being opposed by all countries. I mean, again, EU, Arab countries, and many others. But what is significant, the arrest warrants that were issued by the ICC for Galat and Netanyahu were based mainly on using starvation or food and humanitarian as the weapon in the war over Gaza. So it would be also part of this. The the Gaza Humanitarian Foundation that was created by the Americans, the Israelis, I mean, as you know, has proven to be part of the problem, reproduces the misery, the chaos, and it's death traps where people were more than 1,000 now have been killed. So there is, a very legitimate and valid issue here to be proceeded with and to follow up. Yes, of course. And we are working on it, by the way. We are working.
Much, Issam, for sharing. Haydee, do you want to go next?
Sure. Yeah, I can quickly answer that. I think the person asked the question said that they were working in immigration and asylum in the US. So first of all, just want to say thank you for the work that you're doing, because I know that's so important right now and really difficult work. So well done on that. But just to the question of how you might be able to contribute to the various strategic litigation strategies. I think, first of all, potentially looking to partner with these organizations that are looking at strategic litigation, looking at international remedies. There's always the possibility that your work might reveal some evidence that could be critical or helpful to this litigation. Of course, in making sure that it's safe for your clients in order to contribute to that, but keeping an eye out for that and seeing how that might be able to support these initiatives. I think another thing to consider as well is how you could potentially use international remedies as an additional remedy to your clients' cases as well. So, you're looking at the domestic immigration remedies that are available for your client, but how can international remedies as well support your client's case in addition? So, whether it's looking at measures before the UN, whether it's the Working Group on Arbitrary Detention or under special procedures before special rapporteurs of the UN, making submissions there in order to emphasize how international law is rooted in your client's case, and also to support international law right now at a time when we're seeing it under attack, being undermined. The more that it's being used, the more that it's being utilized in these cases emphasizes that it's still relevant and very important as well.
Thank you very much. I would also now like to give each speaker maybe 1 or 2 minutes for a final wrap-up, or any final comment, or any questions you saw in the chat which maybe haven't been answered yet, which you would like to address. So, Issam, if you would like to go first.
Well, no more to add, just to thank friends, the panelists, for this very interesting and informative presentations that I myself benefited a lot from. And again, as I said, I mean, the priority for us is how to stop the war. And I think there is a room for this, and we have to intensify our efforts, especially people are paying very, very high price, and time, again, is being calculated very different now. And again, back to what I said at the beginning, that now more than 6 or 8 people have been killed while we are talking about genocide in Gaza. So the second point, if you allow me, I mean, we have to be this time critical. We should have our own narrative that should be different. I mean, it's not a psychotherapy to use and utilize universal jurisdiction. We have spent a lot of resources, a lot of money. It doesn't mean that it's, I mean, we have to keep engaging, but it's by itself is I mean, is will not bring what we dream of. We have to consider other ways to put the issues of accountability, justice on the table. While Haydee was talking about, you know, how we utilize international remedies for refugees, I think protection is the issue for Palestinians at the moment. They lack. I mean, even people who left Gaza, they, for example, they don't have any uh, sort of protection. Gazans are not eligible for any visas, for example, because they don't have residence permits in any country where they are. And so they are very important issue, very pressuring, and we have to deal with them this time. I believe differently. It's time. It's a moment of the truth. If if things continue this way, the worst is definitely coming. Definitely is coming. And I think the way that we still engaging with the system, with countries, with the universal jurisdiction, I think it will, you know, kind of reproduce the, I don't say the misery, but will reproduce the way, maybe the same results. There is a context now. There is an atmosphere. There is people who are fed up with the tolerating genocide that's being live streamed. And then there is a room, and we should say the word now and convey the word for others. Yeah, and thank you so much for your time. Thank you.
Thank you, Issam. Haydee, would you like to go next?
Sure. Just in the final moments that I have, I did notice that there was one question that just asked for a bit of an update on Global 195 and potential partners and how that's moving forward. So let me just say that ICJP has been trying to do this as carefully and deliberately as possible, carefully considering each complaint as it goes. There was quite a high volume of requests to engage with ICJP, and it's in the process of mapping out partners and groups. And so, but it certainly does welcome all interest in working together. And I think on that note, what I'd probably say as my final words is the biggest takeaway that I've had from this discussion today is the importance of working together, that we're stronger together, that it's so important to look at these partnerships and these coalitions in order to achieve these goals and make sure that the rule of law and the protection for Palestinians is achieved and ensured. So thank you very much for everyone's interest, and look forward to having more discussions on this.
Thank you. And Robert?
Yes, I saw 2 further questions in the chat pointing at the obvious inconsistencies, and you might even say hypocrisy of governments, because on the one hand we have very clear international legislation or even domestic legislation, and then officials do not enforce it. And Germany is perhaps one of the most blatant cases. The German government does not even enforce its own domestic laws, such as the Corporate Due Diligence Act. And even though it is very clearly prohibited to aid and abet genocides, our government still, and has done so continuously, permits weapons exports to the State of Israel. That is an obvious inconsistency. There are, I can only explain it by telling you that there are people in power who are very determined and committed to be in solidarity with the Israeli government, no matter what. There's an unconditional support that is eternal, unconditional and eternal, to an extent that should remind anyone of the determination with which the Nazis committed the Holocaust. And it is shocking and appalling. And I want you to know that there are many lawyers in Germany that are shocked and appalled by that as well. Not everyone is very outspoken, but I think many of us are impressed by the global movement of lawyers abroad, also of people on the streets everywhere in the world. And we are hoping that our government also will be pressured with through diplomatic ties and just keep pointing out obvious hypocrisy. And thank you for everyone outside of Germany that is pushing for change.
Thanks so much, Robert. Okay, then I would like to now go to the concluding remarks of the panel. And I also want to thank Issam for reminding us of that the universal jurisdiction is not a charity, but it's a duty of states to really act in this way. And also thank you and all the Al-Mezan colleagues for the work you do in the documenting and the push for legal efforts. And then also thank you, Haydee, for showing us the power of universal jurisdiction and the work of the Global 195 campaign. And I also really agree with what you're saying about echoing the work of partnerships and of coalitions and organizations and bringing them together. And just to link into that, I know that several organizations are working on a strategic litigation toolkit, which is coming out in September, which supports lawyers, activists, and civil society organizations in providing the tools for strategic litigation work. So this is also something we can definitely watch. And thank you, Robert, for underlining the practical tools we have, particularly on business and human rights, and the larger relevance it has for the other European states. And Gary, who's unfortunately not here anymore, but who really clearly walked us through like the strategies for accessory liability and anti-money laundering regimes. And it's really, I learned a lot also from his intervention. So thank you to all the speakers for your expertise and your tireless work. And a special thank you.
Thank you, Hannah, for your fantastic and wonderful moderation. Thank you.
Exactly. Thank you.
But also a special thank you to the interpreters, Noor and Amani, for making the discussion accessible, also in Arabic. Many thanks for that. And thank you for everyone who joined, whether via Zoom or via the platform, who is watching it later on YouTube. The recording of this panel will be available on YouTube, so you can share it after or watch it later again. And let's keep building up these networks and pushing for real accountability. Thank you, everyone, and have a great evening.
Thank you. Thank you so much.
Thank you. Goodbye.
Everyone.